So imagine someone just recklessly swings a baseball bat right in your living room and, completely shatters your prized antique vase.
Oh, man. Yeah, that would be awful.
Right, and I mean, common sense just screams that they should be the one to pay to replace it.
Exactly.
But what if I told you there's this complex mathematical formula that basically proves society as a whole would be much wealthier if we just, let the bat swinger walk away scot-free?
I mean, honestly, it immediately triggers this deeply ingrained sense of outrage.
Yeah,
We
totally.
look at the shattered porcelain, we look at the guy holding the bat,
Mhm.
and our brains just demand a straight line between the two. Like, did your specific action cause this specific damage?
And if yes, you pay.
Right. That backward-looking, individualized inquiry is, it's the absolute bedrock of what the law calls actual causation. It's basically the engine of corrective justice.
Which makes sense to most of us. Yet, in this deep dive today, we are jumping into this massive, decades-long intellectual wrestling match because there was this incredibly influential school of thought that looked at that exact common sense instinct and just decided it was completely backwards.
Yeah, they really did.
We're exploring a brilliantly argued 1985 paper by a legal scholar named Richard W. Wright. It's called Actual Causation versus Probabilistic Linkage, the Bane of Economic Analysis.
It's quite a title.
It is. And our mission today is to kind of watch Wright systematically dismantle the attempts of three major economic thinkers who tried to, well, fundamentally erase actual causation from the legal system.
And, to understand why they wanted to erase it, we really have to look at how these economic analysts actually view the law.
Okay, lay it out for us.
Well, they don't see the legal system as this mechanism for righting past wrongs.
Man.
To an economist, a past injury is just, it's a sunk cost.
Right.
The vase is broken. Moving money from the bat swinger's bank account over to yours doesn't magically unbreak the vase. It just shifts the wealth around.
Yeah. So what do they want the law to do instead?
They want to use it as this forward-looking behavioral steering wheel,
Yeah.
basically. They want to assign liability purely to deter future inefficient behavior, maximizing aggregate social wealth.
I see. So they want a calculator that minimizes future social costs rather than a judge who's weighing moral responsibility.
Exactly.
They want to base liability on what they call probabilistic linkage, which is essentially just asking who increased the statistical risk of an accident happening.
Right. But the law stubbornly insists on actual causation. The courts demand actual proof that you caused the harm, not just that you bumped up the probability of it.
So these economic theorists basically tried to force the square peg of backward-looking causation into the round hole of forward-looking economic efficiency.
And as Wright documents so masterfully, one by one, the wood just splinters. The systems are fundamentally incompatible.
Okay, let's unpack this. Because Wright puts some really major theorists in the hot seat, starting with Guido Calabresi.
Right, Calabresi.
Since these economic analysts viewed actual causation as this annoying, irrational hurdle to their beautiful market efficiency, Calabresi took the first swing. He basically tried to explain the causation requirement away.
Yeah, he claimed it was essentially an illusion, like a smokescreen that courts use to achieve three broad policy goals.
And what were those goals?
Well, first he argued that when a judge talks about causation, they aren't actually looking for a factual link. He claimed they're secretly aiming for collective deterrence, which is just banning activities society deems wildly inefficient.
Okay, that's one.
Or second, they're aiming for market deterrence, forcing the cheapest cost avoider to pay.
Wait, the cheapest cost avoider.
Yeah, that's just economist speak for the person who was in the best position to cheaply prevent the accident from happening in the first place.
Okay, that makes it kind of cold, calculating sense, I guess. But his third goal is where the logic really just falls off a cliff for me.
Oh, the loss spreading.
Yes. He argued courts are primarily trying to minimize secondary costs by finding the best loss spreader. They're basically looking for the deepest pocket.
Yep, that's the one.
So if we go back to my broken vase example, if I swing the bat and break your vase, Calabresi's theory might actually suggest that your wealthy uncle should pay for it.
Which sounds insane to a normal person.
Right. Why? Just because he has deep pockets and can absorb the financial hit without a devastating impact on his life, it completely bypasses the fact that I was the reckless one. It turns the whole legal system into a mandatory societal insurance policy.
And the flaw in that thinking is massive. Wright targets it relentlessly. He points out that there's absolutely no necessary connection between the party who actually caused a loss and the party who's best equipped to spread the cost.
None at all.
Calabresi's theory relies entirely on forward-looking probabilistic linkage, looking at future risk and wealth distribution.
But it completely fails to explain why courts, century after century, stubbornly refuse to find the rich uncle.
Exactly. The courts always zero in on the bad swinger. So Calabresi really cannot explain the persistence of the actual causation requirement.
And Wright uses this legendary law school case to prove how Calabresi's forward-looking model just collapses. Paul's graph v. Long Island Railroad.
Oh, Paul's graph. Every law student's favorite nightmare.
It's so wild. I'll lay out the facts for you because it really plays out like this ridiculous Rube Goldberg machine of disaster.
Go for it.
So railroad guards are trying to help a passenger onto a moving train. They push him a bit too hard, and he drops a package.
Which seems harmless enough.
Right. Nobody knows this, but the package is full of fireworks.
Of course it is.
So the fireworks hit the rails and they explode. And then the shock wave from this explosion travels all the way down the platform and knocks over these heavy scales.
Which fall and injure Mrs. Polsgraf, who was just standing far away minding her own business.
Exactly. It is the ultimate example of an unforeseeable injury. And it just completely breaks Calabresi's economic deterrence model.
It really does. Think about it from his perspective of market efficiency. If an injury is entirely unforeseeable to the actor, penalizing them doesn't send any useful economic signal to future actors.
You can't deter a railroad guard from taking a risk they couldn't possibly know existed.
Right. If the guards were already exercising what they thought was reasonable care to, say, prevent someone from tripping, the extra cost to prevent a random, invisible fireworks explosion 50 feet away is zero.
Because they wouldn't have changed their behavior at all.
Exactly. From a purely forward-looking, wealth-maximizing perspective, imposing liability in the Palsgraf case is utterly useless. It achieves zero market deterrence.
It just arbitrarily punishes a railroad.
Yeah. Yet in traditional court law, whether the guard's actions actually caused that bizarre chain of events is still the foundational question the court absolutely must answer.
So Calabresi tries to write off actual causation as this policy illusion, but Wright shows that Calabresi is using a forward-looking lens to explain a stubbornly backward-looking requirement.
It just doesn't fit.
Not at all. And because Calabresi's broad policy arguments couldn't kill off actual causation, the economic analysts realized they had to escalate. They needed heavier artillery.
Enter Stephen Shavell.
Right. A theorist named Stephen Shavell stepped into the ring. And he brought these strict mathematical formulas to try and prove that actual causation is somehow a mathematical necessity for economic wealth maximization.
Yeah, Shavell abandoned all those messy policy arguments and built these complex, idealized mathematical models. His primary fear was what he called crushing liability.
Crushing liability.
Yeah. In the economic mindset, if actors are held liable for every single ripple effect of their actions, the financial burden just becomes infinite.
Oh, I see.
And that crushing liability would terrify people into just staying home. Businesses would shutter, and socially beneficial activities would just grind to a halt.
Okay, so to prove we need strict mathematical boundaries on liability, Shavell creates this incredibly contrived hypothetical scenario. I need you to walk me through this because the math here sounds completely insane.
It is a bit out there.
He imagines this park with terrible visibility, and a jogger is running through the park, and no matter what, is absolutely guaranteed to trip over a fallen branch and sprain their ankle. It is mathematically destined to happen.
Right, the branch is unavoidable.
But then a bicyclist decides to ride through the park, and the bicyclist blindly crashes into the jogger just before the jogger reaches the branch, causing the exact same ankle sprain.
Yeah, it is highly artificial setup. But Shavell used it to make a really stark economic point. He argues that mathematically, the bicyclist shouldn't be held liable for the jogger's sprained ankle.
Wait, stop. You're telling me Shavell built a model where a bicyclist violently crashing into a pedestrian is considered perfectly fine and they shouldn't pay a dime?
Under his strict economic calculus,
Yeah.
yes.
Wow.
Because Shavell argues that the bicyclist's presence in the park didn't actually increase the aggregate level of loss in the world.
Because the jogger was walking away with a sprained ankle either way.
Exactly. Shavell claims that if we hold the bicyclist liable, all bicyclists will face crushing liability for accidents that were mathematically destined to happen anyway. They'll stop riding bikes, the bicycle industry suffers, and overall social wealth decreases.
That is quite the leap.
Right. Therefore, he concludes, his math proves that we must have a strict but-for test to protect the economy.
It's a fascinating mind game, really, but Wright just tears it to shreds. Wright points out that Shavell is completely confusing the forward-looking risk, what we'd call the ex-ante probability before anyone sets foot in the park, with the backward-looking ex-post reality of who actually caused the crash.
What's fascinating here is how Wright exposes this as preemptive causation.
Preemptive causation.
In the real world, outside of an economist's spreadsheet, the fact that the jogger would have tripped on a branch in some alternate timeline, it doesn't erase the physical reality that the bicyclist did hit them first.
Yeah, the bicycle preempted the branch.
Exactly. And real-world courts have absolutely no problem identifying the bicyclist as the actual cause of the injury. They don't care about the alternate timeline.
And to really hammer the final nail in Shavell's mathematical coffin, Wright brings in two real-world legal scenarios where this strict math just totally breaks down.
Oh, yeah. Duplicative causation and alternative causation.
Let's look at duplicative causation first. So, two separate people negligently start fires in a forest. The fires merge into this massive inferno and burn down my house.
Yep.
And either fire alone was big enough to destroy the property.
Right. So if we strictly apply Shavell's mathematical but-for test here, the result is pretty astonishing.
How so?
Well, you cannot say but for fire A, the house would be standing, because fire B would have burned it down anyway.
Okay, yeah.
You can't say, but for fire B, the house would be standing, because fire A was right there doing the same thing.
So Shavell's strict economic math dictates that neither fire starter is a necessary cause, so neither should pay.
That's what his math says.
Let me push back on that, because that is pure lunacy. If two people burn down my house, Shavell's math says I get absolutely nothing, and they both get away with it.
Pretty much.
The courts can't possibly operate that way.
They don't, and that is Wright's entire point.
Yeah.
In real life, the courts just throw Shavell's economic model right out the window. They hold both fire starters fully liable because they both contributed to the actual harm.
Thank goodness.
Yeah, the courts prioritize individual accountability over aggregate mathematical elegance.
And then the alternative causation scenario is even wilder. The classic case for this is Summers v. Tice.
A legendary case.
So three men are hunting quail. Two of the hunters negligently fire their shotguns at the exact same moment in the direction of the third hunter. A single pellet strikes the victim in the eye.
It's terrible.
It is, but it is physically, scientifically impossible to know which of the two negligent hunters fired the specific pellet that caused the injury.
And this is where Shavell's proof completely unravels. Because looking at its ante, from a purely forward-looking risk perspective before anyone pulled a trigger, the probability of both hunters hitting the victim simultaneously with a single pellet was virtually zero.
Right.
Shavell confuses this forward-looking probability with the backward-looking reality that one of them absolutely definitely caused the blinding. Because the victim cannot mathematically prove but-for causation against either specific hunter, Shavell's strict analysis would leave the innocent, blinded victim with nothing.
Wow. But the court in Summers v. Tice refused to let the economists win. The court held both hunters liable.
Yep.
They essentially said, you both acted recklessly, one of you caused this, so you figure out how to split the bill among yourselves. The courts just broke the strict mathematical rules of probability to ensure that corrective justice was served for the victim.
Shavell's ultimate failure is that his models require a fantasy world to function. I mean, they rely on victims being completely passive entities who never try to avoid injury, and they require courts to be completely omniscient, possessing this perfect, godlike knowledge of all statistical probabilities.
Which obviously isn't real.
Exactly. Since that world doesn't exist, his attempt to justify actual causation through aggregate math fails just as spectacularly as Calabresi's policy attempt.
Which brings us to the final and honestly the most desperate attempt to conquer actual causation.
Oh boy.
Right? Calabresi's policy failed. Shavell's math fell apart when faced with the messy reality of forest fires and hunting accidents. So our final theorists, William Landis and Richard Posner, basically took the nuclear option.
They really did.
They looked at this stubbornly persistent concept of actual causation and basically tried to gaslight the legal profession. They claimed it doesn't actually exist at all.
It is a breathtakingly audacious leap. Landis and Posner argued that actual causation is completely dispensable. They claimed that every single tort case in history could be entirely explained by something called the Hand formula.
We should definitely define that because it's crucial to their trick. The Hand formula, which is named after Judge Learned Hand, is an algebraic formula for economic efficiency.
Right.
It simply says a person is negligent if the cost of taking a safety precaution is less than the probability of an accident happening, multiplied by the gravity of the loss.
Exactly. It's pure cost-benefit analysis.
Like, is it cheaper to install a safety rail, or is it cheaper to just pay out the occasional lawsuit when someone falls off the ledge?
Spot on. It's a tool for measuring forward-looking efficiency. But Landis and Posner argued that when judges write these lengthy opinions about actual causation, they are secretly just doing hand formula math in their heads.
That's a bold claim.
It is, and Wright exposes how Landis and Posner have to aggressively bend reality, basically using the magic of hindsight, to make this theory hold up.
Here's where it gets really interesting. Wright uses a case called Weeks v. McNulty to expose the cheating.
A great example.
So in this case, a hotel owner was required by law to install fire escapes. He didn't do it. A fire breaks out, a guest panics, and tragically dies in the flames.
Right.
But the court looked at the evidence and concluded that because the guest panicked and ran the wrong way, they would never have reached the fire escapes even if they had been perfectly installed.
So traditional tort law looks at this and says, okay, the hotel owner was definitely negligent for not installing the escapes. But that negligence was not the actual cause of the death because the escapes wouldn't have been used anyway.
So no liability.
Exactly. Therefore, no liability.
It makes sense intuitively. But if Landis and Posner claim actual causation doesn't exist, how on earth do they explain the hotel owner getting off the hook using only the hand formula's cost-benefit analysis?
Through some severe logical contortions. They argue that because the specific guest in question wouldn't have reached the fire escapes, the expected benefit of spending money to install those fire escapes was actually zero.
Wait.
Yeah, and because the expected benefit was zero, the hotel owner's failure to spend the money was actually economically efficient.
I have to stop you there because that is so blatantly cheating.
It really is.
Looking at it before the fire ever started, the expected benefit of installing fire escapes in a crowded hotel is incredibly high. I mean, it protects hundreds of potential guests.
Right.
Landis and Posner are taking what happened after the fact, the specific, unpredictable panic of one guest, and retroactively pretending that was the expected forward-looking probability from the very beginning.
You've spotted the exact sleight of hand Wright calls them out on. They claim to be using a forward-looking risk analysis, but they are secretly smuggling in the backward-looking actual causation reality that they claim to despise.
Wow.
They just manipulate the math in hindsight to make it match the court's result.
And the absurdity really peaks with the speeding trolley case, Berry v. Sugar Notch Borough.
Oh, this one's wild.
Yeah, so a motorman is driving a trolley down the tracks, and he is speeding. He's acting negligently. Suddenly, a severe windstorm blows a massive tree down, crushing the trolley and injuring the speeding motorman.
A total freak accident.
Right. So the town tries to get out of paying for the dangerous tree by arguing the motorman was contributorily negligent by speeding.
And traditional tort law says the motorman speeding was negligent regarding the risk of colliding with another cart, but it lacked actual causation regarding the falling tree.
Because the tree falling was just a random act of nature.
Exactly. So the court allowed the motorman to recover damages. But Landis and Posner have to explain this using only forward-looking economic efficiency.
Let me push back on their physics here, which is exactly what the court realized too. If the trolley was speeding, the motorman was actually under the dangerous tree for less time.
Yep.
Speeding technically decreased his statistical risk of getting crushed by a falling object at any given coordinate. If he had been driving the speed limit, he might have passed under the tree minutes after it fell. The speeding didn't increase the risk of a tree falling on him.
Exactly right. If Landis and Posner evaluated the motorman's speeding objectively beforehand, they would have to admit his speeding increased the risk of collisions, making him an inefficient actor who should be barred from recovering damages.
But the court did let him recover.
Right. So how do Landis and Posner twist their economic theory to match the judge's ruling?
Don't tell me they use hindsight again.
They absolutely do. They argue that because the speeding trolley was in fact hit by the tree, we must mathematically conclude that the speeding created a 100% probability of that specific accident happening.
That's not how probability works. You cannot say that driving 10 miles over the speed limit guarantees a tree will fall on you just because it happened to occur this one specific time.
It's entirely backward. As Wright points out, if they applied this logic consistently, anyone who drives carefully, obeys all traffic laws, but still gets sideswiped by a drunk driver would be considered economically inefficient.
Why? Because in hindsight, the crash happened.
Exactly.
Hmm.
According to Landis and Posner, the expected cost of their careful driving that day was a 100% chance of a massive crash.
That is ridiculous.
It is. Wright proves conclusively that Landis and Posner are just relying on the traditional backward-looking actual causation requirement, slapping a fake economic label on it, and just hoping nobody checks their math.
So what does this all mean? We've watched Wright systematically dismantle Calabresi's policy illusions, Shavell's contrived math models, and Landis and Posner's hindsight gaslighting.
Wright's ultimate conclusion is basically a resounding vindication of traditional human justice. He proves that the actual causation requirement is not some meaningless, manipulable hurdle that gets in the way of economic perfection.
Right.
It is a solid, definite, and vital requirement. It insists that liability must be conditioned on a backward-looking inquiry into individual responsibility for tortious behavior that actually contributed to an injury.
You simply cannot take a legal system built on the moral foundation of individual corrective justice and force it to operate as a cold, calculating machine for aggregate wealth maximization.
You really can't.
And connecting this back to you, listening right now, think about how you consume news. When you read about a massive corporate lawsuit, an environmental disaster, or a medical malpractice case, your human instinct is always to ask, did that person's actions actually cause the harm?
Always.
This deep dive proves that your intuition for corrective justice is incredibly powerful. It is so deeply embedded in our legal DNA that decades of the most complex, sophisticated economic modeling from the brightest minds haven't been able to erase it from the law. We still demand that the person who swung the bat pays for the broken vase.
Which brings us to a fascinating frontier to leave you pondering. We've talked about a 1985 debate, but what happens when we apply this to tomorrow's technology?
Oh, like AI.
Exactly. Think about the rise of artificial intelligence and self-driving cars. These autonomous vehicles are literally programmed using the forward-looking economic math we've discussed today.
Evaluating probabilities, expected benefits, acceptable losses in real time.
Right. So if a self-driving car algorithm decides that swerving into a pedestrian is mathematically the most efficient way to minimize overall damage in a crash, how will our legal system respond?
That's a terrifying thought.
Will we finally surrender to the economic analysts and accept that the injury was just an efficient outcome of probabilistic linkage? Or will our stubborn human demand for actual causation, for finding out who is responsible for the wreckage, force us to put the algorithm itself on trial?